All right, y'all, what's up? Check me out. March the 6th, 2025. Sean Gumby, me, my son, Sean Xavier Gumby Jr., myself, Sean Xavier Gumby Sr., the podcast was sold. Astigmatism in my soul and Gumby Publishing. We do not wish to hurt anybody. We do not wish to defame, slander, or libel anybody. We do not wish to defame anybody. What we are discussing today are publicly available court records that you can download, and the whole world can see them. And we're going to be coming straight from these court documents today. Shout out to everybody. Welcome all the new subscribers. I appreciate y'all. Make sure you go follow me on Spotify. You can listen to all of my videos on Spotify. The podcast was sold on Spotify. You could also listen to me on Instagram. The podcast was sold. If you want to email me, my email address is thepodcastwassold@gmail.com. So today we're going to be coming from 3 documents, right? But the first one we're going to cover is the government's response to defendants' motion to suppress wire and electronic communications. So this is the United States versus Dion Gatlin, which is Cuffy. All of the paperwork, all y'all been saying, yo, Sean, read Cuffy's paperwork, read Cuffy's paperwork. All the paperwork that I have been reading is Cuffy's paperwork. The only paperwork that I've read that was purely Big Meech's paperwork was his sentencing hearing. I did a video on that, and his compassionate release, and his 2-point reductions that he got. But everything else has been Cuffy's paperwork. I haven't read no one else's paperwork but Dion Gatlin. So Cuffy Cuffy filed a motion to suppress. Him and Andre Rush filed a motion to suppress the wiretap evidence. Okay? And they get denied, right? Because Cuffy's position is that the reliability of CS1, which is Tammy Cowins, and they don't have probable cause in order to let the wiretaps be admissible as evidence against them, right? So the judge goes through, and altogether there were 7 separate affidavits filed by the St. Louis DEA, but the one that everybody's dealing with in particular is the one that's dated August 28th, 2012. That's the one of import. And the judge expresses that, because the one that's done August the 28th, 2012 is the first affidavit. Any subsequent affidavit that comes behind that is going to be justified, because it's going to be justified and have more evidence of probable cause and exhaustive investigation techniques, because it's subsequent to the first one. So if the first one is probable cause, then the other ones that come behind it, the 6 other ones, are going to be good. Now, one of the arguments and one of the bars that the government has to establish is that they did exhaustive means in terms of exhausting all other avenues of trying to get the information, to get probable cause information on the defendants, Cuffy, Andre Rush, Timothy Rush, before they chose the wiretaps. You just can't dip straight to the wiretaps. First, you gotta try looking in my man's trash. You gotta try surveillance. You got to try tracking devices. You got to try informants. You got to try outright surveillance, right? And if you're not successful, and you have to exhaust all of those means, if you're not successful at getting the information you need that way, boom, then you could get the wiretap joint and do what you got to do. So, the defendants argue that the federal orders authorizing the interception of wire communications were defective because the orders were predicated upon an affidavit that failed to establish probable cause, establish that investigators had exhausted normal investigative techniques, which I just went over, right? So, they get the affidavit, and then every 10 days, they put in an order. A DEA agent amends the application and extends the surveillance by 10 days, and they do this several times. The first one, I think the affidavits, the wiretaps were good for 30 days. And if you're getting information, you could extend it for 10 days, but you got to keep going through the U.S. attorney, and the U.S. attorney has to get it to the judge, and you have to show that you're getting some good information on these wiretaps in order for the government to continue to sign off on them. Now, this goes on. The first one is August the 28th, 2012. Then they come back September 10th, 2012, September 18th, 2012, September 27th, 2012, October 4th, 2012, October 15th, 2012, October 24th, 2012, November 5th, 2012. All of these dates, October 23rd, 2012, and they list the phone numbers. So this document is government's response to defendant's motion to suppress wire and electronic communications. It's a 19-page document. And then we're also going to be coming from the original motion to suppress, all right, where we started off at, which was the 32-page document, right? The 32-page joint. So we're dealing with Cuffy and Andre Rush getting their motion denied to suppress the wiretaps, all right? And so, probable cause. Defendants Dion Gatlin and Andre Rush argue that there was no probable cause to support an order authorizing the interception of wire and electronic communications. This is on page 6 of 19. Then the government, the judge sets forth what is the bar that's necessary to achieve in order to permit a judge to get a judge to sign off on a wiretap, to permit law enforcement to get wiretaps. The standard that a reviewing judge must follow to determine whether there is probably cause to support issuance of a search warrant is as follows. Right here, this is page 7. The task of the issuing judge is simply to make a practical, common sense decision whether, given all of the circumstances set forth in the affidavit before him, including veracity and basis of knowledge of persons supplying hearsay information. So veracity, if you look that word up, veracity, is like honesty, trustworthiness, right? And basis of knowledge, do they really know? There is a fair probability that contraband or evidence of a crime will be found in a particular place. And the duty of a reviewing court is simply to ensure that the judge had a substantial basis concluding that probable cause existed. Now, check me out. Page 7. The judge says, we do not review affidavits in a hyper-technical manner, but rather with an eye toward common sense denomination. Further down on page 7. Statements by a reliable confidential informant without more may provide a sufficient basis for the issuance of a search warrant. Even an anonymous tip from an informer may serve as a basis for probable cause as long as its reliability is established through corroboration. As long as its reliability, so when somebody says something, when Tammy Cowins says something, or an informant says something, the DEA or the police have to go behind and verify, double check. Is what they saying right and exact? Is it money, or are they ain't telling the truth? Okay? Now, this is the key. This document, right? Let me stay here first, and I'm going to remember to come back. The affidavit contains information obtained from confidential source who had been found to be reliable. The August 28, 2012 affidavit. Information provided by the confidential source was corroborated through toll analysis, past criminal investigations, and through the monitoring of phone calls by DEA agents. August 28, 2012 affidavit. Defendant Gatling asserts that all the information provided by CS1 was relayed to agents in St. Louis through DEA agents in Atlanta. The judge says this is simply not true. CS1 contacted agents in Atlanta, Georgia, who contacted agents in St. Louis, Missouri, because Suarez was to provide Gatling with large quantities of cocaine in St. Louis, Missouri. DEA agents in St. Louis then spoke with Tammy Cowins in the affidavit August 28, 2012. However, after Tammy Cowins told them about Suarez getting ready to get money with Cuffy, right? The DEA agents have to corroborate that. Remember we said that before? They got to go by and verify. So they spoke with Tammy. DEA agents in St. Louis then spoke with CS1. However, even if all of the information provided by CS1 was provided to agents in other jurisdictions, the facts provided by Tammy Cowins do not become less compelling. The government is required to demonstrate the reliability of CS1, Tammy Cowins. Often, a confidential source's reliability will have to be determined by the agent or law enforcement officer in the most frequent contact with the confidential source. All of the information, including any information that would negatively impact the confidential source's reliability, is then conveyed to any other investigating officer relying on that confidential source's information. It was incumbent on the agents in St. Louis to speak with the agents in Atlanta at length about Tammy Cowins and the information provided by Tammy Cowins, and is as outlined at length in the affidavit. Communication between the two officers went on throughout the course of the investigation. So, this is the key. This document, this is the document. Check me out. Check me out. Stay right there. Don't hang up. Let's go back to the Jack Harvey cross-examination that we did yesterday. Jack Harvey's cross-examination happens in the 74-page document The Franks hearing dated October 18th, 2016, Volume 2, redacted joint. United States of America versus Cuffy. Now, this is Welby cross-examining Jack Harvey. Remember yesterday? Check me out. The government's response to Cuffy's motion to suppress, denying their motion to suppress, this document is dated, in March of 2015. It says it's filed March the 4th, 2015. Then the last page, the stenographer, whoever is on that last page, says they filed it in April of 2015, but it's dated like March 18th. So March 2015, this is when this document is done. Welby cross-examining Jack Harvey. Remember, Jack Harvey retires in 2011. He don't hear no more from Tammy Cowins until February 2013, when Cuffy gets busted. She calls Jack Harvey for just like to be consoled, to be as a safe person to talk, because now she's afraid. Cuffy and them got busted based upon information she's provided. So she calls him Tammy Cowins calls Jack Harvey February 2013. Then she goes dark for 2 years. Then she starts calling my man back March 2015. 2 years later, she starts calling Jack Harvey again. The same day, the same month that the judge puts in the motion, the judge orders the denial of Cuffy's attempt to suppress the wiretaps, and then the St. Louis DEA files this document, and it's made public. Then Tammy Cowins finds out that this document is made public, and everybody can see it. They go on PACER, it's made public. Now she starts receiving threats. Now she's busted. Not only did she help Cuffy get busted in 2013, you understand? Now everybody knows. Now she's starting to receive threats and that kind of thing. You said that you had discussions. This is Jack Welby cross-examining, Stephen Welby cross-examining Jack Harvey. Welby, you said that you had discussions with Tammy Cowins since, I guess, beginning sometime in February 2013 going forward. Jack Harvey, the first contact I had with Tammy Cowins was February of 2013 since my retirement. Yes. Welby, then as recently as March 2015, you said she forwarded you a text message. Did I understand you correctly? Yes. So someone has sent her a text message on her phone and she knew how to forward that to your phone. Yes. Stephen Welby. They talk about this Keith Cromer sexual relationship. Then Welby asks Harvey, and that she received money that she doesn't know why she was paid. Jack Harvey. Well, the money, she said a lot of things about the money to me. I believe in her own mind she was not overpaid. She probably thinks she was underpaid considering the security concerns that she has. Because after this is made public, the St. Louis DEA didn't protect her for whatever reason. I don't know why. Did they make a mistake and file it unwittingly and forgetting that they needed to keep her a confidential source? Or did they say, man, the hell with her, we filing this joint as is, let her deal with what she got to deal with? You know, she has said to me many times, this is Jack Harvey, Tammy Cowins has said to me many times, I wish I'd never started any of this. I wish I'd never even gone to you on the Terry White case. Come on, Sean. Get it together. I wish I never heard of the DEA. This is what Tammy Cowins says after this is made public and everybody knows who she is. Welby. And then you started receiving calls from Tammy Cowins, mostly in particular in March of 2015. This is page 57 of 74. Is that right? Jack Harvey, no. But there was a series of calls, yes, in March of 2015. Welby, and one of the first things she told you in the series of calls in March of 2015 was that it hurts that most of the document says, and this is Welby pointing to an exhibit, what hurts the most is that the document says, I'm reliable from prior cooperation. They say filings on here, but it's prior cooperating. Jack Harvey. She was hurt by the fact that she was being made known to other people that she had previously assisted the DEA. That upset her. Welby, that she had been reliable in the past. Harvey, that she was being described as having been previously an informant. I assume that was reference to the work she did on the Terry White case. So I just wanted to come back to this because we're tying all of this together. We're tying all of this together. So now let's get back to the judge's motion to deny. The judge's denial. Cuffy, defendant Gallant, also argues that the information provided by Tammy Cowins was not reliable because of the illogical nature of this alleged overhear. Defendant Gallant refers to an explanation of a series of phone calls between Tammy Cowins, Suarez, and Gatling on August the 5th, 2012. During the conversation, Tammy Cowins told Cuffy that Suarez was trying to get in touch with him because Suarez had a truck in St. Louis. Affidavit, August 28, 2012. DEA agents in Atlanta overheard the conversation. Remember, that's plural now. DEA agents between CS1 and Gatling, and that fact was indicated in the affidavit dated August 28, 2012. Tammy Cowins told investigators that she had been contacted by Demetrius Flannery in order to introduce Fidel Suarez to Gatling so that Suarez could begin delivering cocaine to Gatling. Affidavit, August 28, 2012. Now, this is the key. Remember the part in Tammy Cowins' testimony? I got all that stuff down there on the floor. That's all the paperwork. When Tammy Cowins was getting cross-examined, I don't know if it was by Herman, Welby, or Humphrey, she on the stand says that Suarez called her back, or it might even be in this motion to suppress, one of these documents, she comes out of her mouth and says, Suarez, after Cuffy and Suarez get together, Suarez calls her back and says Cuffy didn't pay him, or ran off with the money, or ran off with the drugs and didn't pay him. I don't believe that's true because it's coming out of Tammy Cowins' mouth. But check me out. CS1 had several conversations with Suarez, who told him that he was able to obtain and deliver heroin and cocaine. When Tammy Cowins spoke to Gatlin, Gatlin told Tammy Cowins that he was only interested in cocaine. Each of the conversations that Tammy Cowins had with Suarez and Cuffy were verified by toll analysis. Suarez told Tammy that he had been traveling to St. Louis and that he was in contact with Gatlin. Tammy Cowins said that Suarez contacted her on July the 7th, 2012, and told Tammy Cowins that he was going to be in St. Louis. So what this is saying is that the conspiracy was already going. Cuffy and Suarez were already as early as July, the month before August the 5th, Suarez and Cuffy are in contact with each other. Right? So the thing about Cuffy running off with the drugs, I don't believe that. Here's bottom of page 11. Additionally, the only reason that Tammy Cowins was in contact with Suarez at all was to introduce Suarez to Gatling in order to facilitate the delivery of narcotics to Gatling on behalf of Demetrius Flannery. And they talk more about the affidavit. So this is where the judge puts his flag in the ground and determines that there is probable cause. Page 12 of 19. The information provided by Tammy Cowins may not have been probable cause to warrant authorization to monitor wire communications to and from Gatling's phone. However, the information was not only corroborated by toll analysis, but agents actually overheard conversations between Tammy Cowins and Gatlin and Suarez. Because the information provided by Tammy Cowins was corroborated, the information was sufficient to provide the basis for a finding of probable cause that Gatlin was committing one or more of the target offenses and that he was using target telephone number 1 to commit one or more of the target offenses. So that's it. I don't want to get too deep in this. You can read this on your own. But what struck me, because when I first, my back itching. What struck me when I first began to get into this case, I thought everything happened in a vacuum. Like August 5th, 2012, bang, that was the day, that was the first day that Suarez and Cuffy met, and that was from when things started and then move forward. But reading the judge's denial of the motion to suppress, it details in here that Suarez and Cuffy had been in contact with each other in July, right? So that the conspiracy was already going on, right? And I remember in one of the cross-examinations of Keith Cromer that I read, Keith Cromer said on the stand that Tammy Cowins told him about the conspiracy between Suarez, Meech, and Cuffy. You know, he didn't know nothing about it until Tammy Cowins told him about it. He said that on the stand. And we're going to get into Keith Cromer next. So, Tammy Cowins is upset because the St. Louis DEA files this, makes it public. The niggas in St. Louis now know who it is. You know, these is some serious dudes in St. Louis. They don't play the radio. She knows these guys and she knows how they get down. Now she's scared. She's running back to Jack Harvey for help. But Jack Harvey told her yesterday, you can't unring the bell. We can't undo what has already been done, right? St. Louis DEA filed it, made it public, whether a mistake or on purpose. But whatever the case may be, it's done, and that's it. So that I wanted to go over, and you know, that's it. So Tammy Cowins, this is where we are. So tomorrow I'm gonna be probably starting Keith Cromer, because I got a big file on him. I did 2 cross-examinations. Remember, he did the jam me by phone. Then the judge and the defense attorneys didn't like what he was doing by phone, and they made him fly. That was on a Wednesday, October 17th, 2016. They didn't like the way he was getting down on the phone, and the judge said, yo, be here Friday. So October 19th, him and his attorney jetted up to St. Louis from Atlanta, and then he was put on the stand. But then he was called back in January 2017, and he's cross-examined at length then, and that's the one we're going to be going over. All right, so I'm done, man. I'm tired. I'm finna go do something. I got to run over to Jersey City real quick. Shout out to everybody. Talk to y'all later. Peace.